Law lecture on the free movement of goods within the European Union bloc. Article 34 on the Treaty of Functioning in the EU prohibits quantitative restrictions and measures equating to quantitative restrictions on imports of goods in the bloc. This prevents national laws and government executive policy restricting the imports of goods from other EU member states. In the Dassenville case, the Courts of Justice of the EU held that trading rules enacted by member states with capacity to hinder, stymie, directly or indirectly, actually or potentially, intra-community trade are to be considered as measures equating to quantitative restrictions. Such measures are inclusive of product requirements, packaging and composition, and stipulating stipulations for same, for the purpose of import, restrictive licensing rules, advertising bans that affect imports, and national origin requirements, for example, Made in Ireland labels becoming mandatory prior to the importation for the purposes of vending. In the Cassis de Dijon case, the Court of Justice held that minimum alcohol requirements for imported fruit liquors was a measure equating to quantitative restrictions, in which is established a mutual recognition principle in that a product lawfully sold in one country should be allowed to be sold in others. The policy grounds for a minimal alcohol requirement of fruit liquors was filed by the Germans to be so that there was a minimum standard of fruit liquor, but the imported product allegedly did not reach these standards, and the court held that nonetheless that this was a measure equating to quantitative restriction and interference with the free movement of goods within the bloc. In Keck and Milhoward, a law preventing at-loss selling in supermarkets was not an Article 34 violation, as it applied across all supermarkets equally. Selling arrangements are not measures affecting quantitative restrictions where they apply to all traders operating in that market, and they affect domestic and imported goods equally. Article 35 of the treaty governs the restrictions on exports. It is less frequently litigated. In the Bouhellier case, the imposing of quality inspections on exported watches, but not on the equivalent domestic market, and ensuring quality inspection of same, was discriminatory and violated Article 35 of the Treaty of Functioning of the EU. Justifications for trade restrictions are detailed in Article 36, and these consider derogations provided for in law, public morality, public policy, or public security, the protection of health and life of humans, animals or plants, protection of national treasures, and the protection of industrial and commercial property. A health protection is a justification. In the Dijon case, the restrictive requirements on the bare minimum for fruit liquors to be imported into Germany was a standard and metrics matter, but in the event of a minimum pricing for the purposes of the prevention of consumption of alcohol, as will be seen in the Scotch case, member states may impose restrictions for health reasons, such as the curtailing of the consumption of alcohol, and proportionality demands that restrictions must be necessary and suitable for protecting public health. This will be empirically assessed and may require expert evidence. In the Commission and UK case of 1983, UHT milk requirements for repasteurisation in the United Kingdom was ruled to be disproportionate, as the UK failed to prove that repasteurisation was essential. It could be argued that this was an indirect means of weaponising European Union law for the purposes of restricting trade in the event of for the purposes of public health, so as to disproportionately impact the export of milk from other member states to the UK, competing with that of the import and internal domestic market of the United Kingdom. As the UK failed to prove that repasteurisation was necessary for human health, the restriction was therefore deemed not justified. The Scotch Whisky Association and Lord Advocate 2017 case was an appeal from the Scottish legal system to the ECJ. The member state had introduced a minimal alcohol pricing to reduce alcohol consumption, and this was considered proportionate because no less restrictive alternative, such as an increased tax measure, would have achieved the same goal. Comparing this with the Dijon case, where it was a simple matter of legal metrics for the purposes of the provision of a stated good, that of fruited liquor, there was no argument made on the basis of public health grounds. However, in this case, as there would be no other minimum or no or less restrictive alternative available, it was deemed as justifiable in the interest of public health, as permitted in Article 36 of the Treaty of Functioning of the EU. Finally, restrictions must be proportionate. They have to pursue a legitimate objective, such as that of health protection. They must be necessary to achieve that objective. They must be the least restrictive measure available per the Scotch Whisky and Lord Advocate case. The burden of proof rests on the member state applying the restriction according to the UHT Mill case of the United Kingdom. Domestic trade and the free movement of goods is considered in the Gourmet International case, where Sweden's alcohol advertising bans applied equally to Swedish and foreign traders, thus satisfying the hitherto measures equating to restrictive quantitative restriction of import and export, namely that import of alcohol into Sweden and exporters of the EU bloc seeking to export to Sweden. However, as foreign traders relied greater on advertising so as to access the Swedish consumer and to gain trust of the Swedish consumer, this ban disproportionately impacted exporting member states seeking to export into Sweden and disproportionately advantaged Swedish exporting alcohol producers and the domestic market. And this was held to be contrary to the domestic trade and principles of free movement of goods within the EU. Where there is no interstate factor, a restriction only affects domestic products and does not impact trade in the EU, then therefore the treaty and the functioning of the EU may not apply. This would be regulated by domestic trade law and domestic legal tradition. In the Krantz 1990 case, it was held by the court that a Dutch tax rule impacted domestic firms alone, and therefore the treaty Article 34 did not apply. Where the impact is that equivalent to shared across the border by another member state, therefore the EU treaties will be activated. But for matters internal to the member state and the member state alone, Article 34, Article 35, and therefore Article 36 do not apply.